Okay, we have both of our counsel with us today. Mr. Brown, it's my understanding you represent the appellant in this case. Is that correct?
Yes, Your Honor, that's correct.
And how much time would you like to reserve?
5 minutes for rebuttal, Your Honor.
Okay, and let me turn to your opposing counsel. I'm going to ask you a question that you may find, why? But if I point out that two members of our panel attend at least some sense of class of education in New Orleans, so is it Herbert or Hebert?
It is Herbert, Your Honor.
Okay. Unlike the quarterback for the Saints, number 3, Bobby Hebert. Okay. All right. With that, we are ready to proceed. Mr. Brown, you may go ahead.
Thank you, Your Honors, and may it please the court. My name is Joseph Brown, and I represent the appellant, West Villages Improvement District. We're here today on the appeal of a preliminary injunction, an extraordinary remedy that must be supported by clear, definite, and unequivocal findings, and that has a narrow and limited purpose of the preservation of the status quo pending final hearing and resolution on the merits. The status quo in this case, Your Honor, since 2018 has been West Villages' delivery of irrigation water to the Apolli Grand Paradiso, pursuant to a rate structure adopted through Resolution 2018-18 and pursuant to subsequent agreements entered into between Grand Paradiso and West Villages dealing with the delivery of irrigation water. For that time, West Villages has delivered irrigation water and Grand Paradiso has paid its bills until the instant dispute, which arose because Grand Paradiso decided it didn't like the status quo anymore and that it wanted West Villages water, but didn't want to pay for it pursuant to the existing rate structure and the agreement between the parties.
Judge Smith, you are muted.
Yeah, thank you. Mr. Brown, I think we're familiar with the facts of the case, and I know there's a lot of ground that you need to cover. So let me get to one of the issues that the trial court found with respect to the notice issue, because I think that's something key that we need to figure out. The point the court made with notice is that there was a 7-day notice that was required. And I think your point here is that a public hearing under the enabling statute, the 2004-456, provides for no time period and simply just talks about an opportunity for the public to have for this public hearing. Can we not draw upon the Sunshine Law in 286-011 about reasonable notice and take the facts of this case that the regular meeting had 7 days notice? The other notice that was given on some matters that were put on the agenda were provided more detailed information in the publication. And then when you get to this case, you have this resolution 2018-18, and there's only a 5-day notice. So can't we take from all the facts of this case and state that this was something that was a non-regular board meeting that required the 7-day notice, and just like the board meeting required 7-day notice, that the public hearing should equally have been provided 7-day notice?
No, Your Honor, for a few reasons. Number one, there is a difference between a public meeting, which is what's discussed in the Sunshine Law 286.011, and also regular meetings, which is the term that's used in 189.015, and public hearings. The enabling legislation, the district's charter, requires the district to hold a public hearing prior to adopting rates for its services. There's nothing in the enabling legislation in the district's charter that says that notice has to be published of that public hearing. And that's a legislative prerogative. I mean, we're getting into sort of separation of powers issues when we start talking about what the legislature may require with respect to notice on particular issues that may become before a collegial public body, like the West Villages Board of Supervisors. In this case, the legislature hasn't decided to require that notice.
Then let me ask you this then. Why is it that the publication, if you're not required to have any notice whatsoever, then why is it that the publication stated that notice is given in accordance with 2004-456 in its intent to adopt rate increases?
I think that's just legalese, Your Honor, honestly, boilerplate. I mean, there's nothing, the bottom line is there's nothing in the charter that says legally there has to be notice for that public hearing. And nor does it say that in Chapter 189, nor does that say that in the Sunshine Law in Chapter 286. So
well, let me ask you this then. In order to adopt a resolution such as 2018-18, could it be done simply at a public hearing?
At a public hearing that is a board meeting, yes, Your Honor. So obviously,
no, okay, but now you're mincing both of those words. You're mincing public hearing and a board meeting. But my question was, could you adopt 2018-18 simply at a public hearing without a board meeting?
No, Your Honor, there has to be a board meeting.
They go hand in hand, right? They go hand in hand. And if a board meeting would require the 7-day notice, then why equally wouldn't the public hearing require 7-day notice?
Your Honor, if I may, they don't necessarily go hand in hand. The board can't act until they've held a public hearing. The public hearings don't have to be held at a meeting of a governing body, right? You could have a public hearing and have staff of a city and county present, for example, to ask questions, to take notes, to deliberate transcript of that to the county commission or the city commission, for the city or county commission to take action on at a meeting. There can't be action outside of a meeting, but that doesn't mean that a public hearing has to occur at a meeting.
Okay, so it's your position that under the Sunshine Law, that because this was a public hearing and not a meeting, that the Sunshine Law doesn't apply?
No, Your Honor. Well, it doesn't apply. The Sunshine Law notice requirements don't apply to this specific subject matter. The Sunshine Law doesn't require notice of particular subjects that may become for a collegial body. It requires notice of meetings. And a meeting is defined as a gathering of 2 or more members of a collegial body to discuss or take action on any item that may become reasonably before that body for action. So there's a difference between a meeting, which is that gathering, and a public hearing, which is an opportunity to speak. And in fact, Your Honor, when the district's charter was enacted in 2004, there was no right to speak at public meetings of collegial bodies like this. That didn't occur until 2013 when the legislature enacted 286.0114, which provided the opportunity for public input at public meetings of collegial bodies like this. So what the legislature was doing in 2004 was saying, before you take action on this item, before you take action on rates or fees, you must provide an opportunity for the public to be heard.
And then under your scenario, then, if an opportunity to be heard is what? How else is someone supposed to know they have an opportunity to be heard without some sort of notice?
The opportunity to be heard, Your Honor, is to appear at a meeting. And
how do they know to attend if there's no requirement of notice of that public hearing?
Your Honor, the district's meetings are noticed, so the public is on notice of when those meetings are. The district's agendas are published on their website 7 days in advance. So there is notice of even the specific topics that are going to come before the board at their meetings. The bottom line is the plain language of the district's charter here doesn't require.
And so let me ask you this then: if someone had gone online at that point in time, they would have known that the adoption of the resolution of 2018-18 was up for the agenda on the regular board meeting?
They would have, Your Honor, but the bottom line is that's not necessary. Nothing in the Sunshine Law, there's no case law I'm aware of that says that public collegial bodies are required to give notice of particular items that may come before it, whether or not there's a public hearing on them. So the bottom line is there is no requirement to provide that notice, but in fact, there was notice. There was notice both in the fact that the district published a 5-day notice of the public hearing, and there was notice in the fact that the agenda for that meeting was on its website 7 days in advance, listing this topic and this public hearing is coming before the board.
Is there any, as far as opportunity to be heard in your position, that notice, since it was provided here, because how else can someone go to the meeting? is there any sort of requirement that there be reasonable notice?
That's a sunshine law, again, a sunshine law requirement, Your Honor, for meetings of collegial bodies. It doesn't deal with particular topics or subject matters or public hearings.
But you're saying in this case, because there's no reasonable, it just says opportunity, that, you know, a one-day opportunity would be fine?
Yes, Your Honor, the charter doesn't speak to notice at all. Again, it doesn't. It simply states that there must be an opportunity to be heard. So a public hearing was held and there was an opportunity to be heard. And the district met the notice requirements of Chapter 189.015. There was an annual meeting notice that was published that listed this date, time, and location as one of the district's regular meetings. 189.015 only says 7 days notice must be provided for meetings other than a regular meeting. This was a regular meeting. It was noticed as a regular meeting. The agenda for the meeting calls it a regular meeting. The minutes call it a regular meeting. It was noticed again in connection with a required notice of public hearing on assessments and budgets. There again, Your Honor, so that the legislature required specific notice of a specific topic, the district's imposition of assessments, prior to being able to take action on that. And that was noticed 3 weeks and 4 weeks out. And in connection with those notices, noticing the same date, time, and location, 11 o'clock at the City of Northport City Hall, it also identified again that the board would be holding a regular meeting. And then on top of that, we have the 5-day notice of the actual public hearing itself, which wasn't required.
Didn't the regular meeting go into recess when public comments were invited?
There is language in the minutes, Your Honor, that say recess and then opening of the public hearing and then reconvening of the regular meeting.
So the public hearing technically did not occur at the regular meeting. It occurred in between two sessions of the regular meeting.
Your Honor, there was only one meeting. Again, a meeting is defined as a gathering of 2 or more members of a collegial body. There was only one meeting that day. The members of the Board of Supervisors gathered at 11 o'clock on September 13th, 2018, and they didn't leave. No one left. So it may say recess, but that's putting style above substance. No one left the meeting. There was no break in proceedings. None of that's in the record because it didn't happen.
Let's just correct that. There was a break in the proceedings. No one may have left, but there was a break because the minutes reflect there was a break.
The minutes indicate that they stopped the regular meeting and opened the public hearing, which again deals with the public's opportunity to speak on that particular item. So before
the problem I'm having with that argument, though, is you just tried to draw a significant distinction between public hearings and the meeting. And so if there is a separate public hearing, to go back to Judge Smith's question, how's the public know what's going to be discussed at the public hearing? Are they just supposed to come and see what happens and go from there?
Your Honor, they're supposed to, if you're interested in the proceedings of the West Villages Improvement District, you're supposed to be aware or try and follow the notices that are required, right, of the regular meetings. You know what the regular meetings are. The notices provide information. Each of those notices includes the district's website. I mean, it's the standard here is not to both lead the horse to water and make it drink. The standard here is that reasonable notice is required of meetings. And with respect to the public hearing, there is no notice requirement, just that the opportunity for the public to be heard on that issue before the board takes action. So there isn't some kind of requirement that you have to force the public to be aware. You know, individual published notice. I don't know actual notice. That's not a requirement here. And again, there is no requirement for notice with respect to the public hearing. Only notice of when West Villages is going to be meeting, and that notice was provided multiple times. If the public isn't paying attention to what West Villages is doing, isn't looking for those meeting notices, I can't help that. My client can't help that. That's not what is required by the law. Notice was provided.
Mr. Brown, then if I'm taking what you're saying, then there would be no need for the language in 189.015 that talks about non-regular board meetings, because from what you're saying, there's just everything's a regular board meeting. You know, there'd be no reason for that language for those specific 7-day notice.
No, Your Honor, I'm not saying everything's a regular board meeting, but
well, that's what it sounds like. It sounds like everything's a regular board meeting. Everybody has, you know, they should look at what our regular schedule is and pop in all the time to figure out if and when something is going to substantially affect their rights.
Your Honor, again, the Sunshine Law doesn't require notice of particular subject matters,
but the Sunshine Law requires reasonable notice, and I think that's what we're trying to get to here.
Yes, Your Honor, reasonable notice of meetings of the West Villages Improvement District's Board of Supervisors. Yes, and the 189.015 language, to get back to your question about regular meetings, there's a requirement to publish that schedule of regular meetings on an annual, semi-annual, or quarterly basis. That notice was published. So there is at the start of the year, there's a list of here are the regular meeting date, times, and locations for the West Villages Board of Supervisors. So if you were interested in, you lived in the community, you want to know when this are, there's the notice. You can, put it on your calendar. You know when the meetings are coming up. You can check in to see what's on the agenda for those meetings. And those are the regular meetings. If there's a meeting outside of when those regular meetings are noticed, then that would be a non-regular meeting that would be subject to the 7-day notice requirement that's in 189.015. So
are you saying that there were, other than the regular meetings, there were other meetings that were set that were non-emergency meetings?
I don't know.
Mr. Brown, before you answer, I need to let you know you are invading the corpus of your reserved time.
Okay, Your Honor.
Respond to the question, but I need to let you know that you were doing that.
Thank you, Your Honor. There's nothing in the record, Your Honor, that talks about special meetings. I mean, this didn't involve a special meeting. It involved a regular meeting. The September 13th, 2018 meeting where that resolution was considered was one of the noticed regular meetings at the start of the year. So if it had not occurred, if the meeting had occurred on September 14th, that would have been a special meeting because it's not the regular meeting, because the regular meeting was September 13th at 11 a.m. So if the meeting had been held on the 14th, there would have been a 7-day notice requirement because it wasn't the already established regular meeting date, time, and location for the West Villages Improvement District Board of Supervisors.
Thank you.
Your Honor, I'll yield here and save my time on rebuttal.
I just did that for you.
Okay, thank you.
I'm sorry I made that assumption, but I thought when we stopped, that's what you were doing. Next time I'll be sure to let you know that I did that so you won't have to worry. Okay. Mr. Herbert, the floor is yours, sir.
Hey, good morning, Your Honors. Joseph Herbert here on behalf of the Appali Grand Paradiso Owners Association. The Sunshine Law was designed and enacted in order to protect the people of this state from government actions being taken out of the sunshine. I'm shocked, but what I've heard today, the arguments that have been made are to attempt to construe the law to allow the West Villages Improvement District, which serves the residents of its community, to provide as little notice is absolutely humanly possible in order to try to get away with passing legislation that would have affected residents for the next 100 years to the tune of $2.8 billion.
Mr. Herbert, so help us understand and reach the point that the trial court did, which was as far as that notice was required to be given of 7 days, consistent with the rate increase of 189. So we have here a public hearing, and the only place that I can find that discusses specifically a public hearing is in the enabling chapter, which is 2004-456, creating the special district. 189.015 doesn't have mention of a public hearing. The Sunshine Law doesn't have public hearing. Each of those statutes talk about meetings. So why should the 7-day of 189 be applied to a public hearing when this was a regular board meeting, as Mr. Brown suggests?
Well, I think Your Honor, as well as Judge Silverman, touched on exactly what portion of the enabling legislation mandates this 7-day notice provision, which is that the stated requirement under the enabling legislation is that the people of the community be given a reasonable opportunity to be heard.
Okay, opportunity, not reasonable. Because I've gone back, yeah, it just says opportunity.
Correct, Your Honor. I think you must, Your Honor, the court must read opportunity to be heard carries with it implicitly the contrary to the, I think, unfair characterization of saying you can lead the horse to water and not make it drink. If we look at Defendant's Exhibit O, which was in the record at 1154 to 1157, the notice under the enabling legislation, the opportunity to be heard must be read in conjunction with the Sunshine Law 189.015 requirement that there be reasonable notice. How would the persons of the community know what's going to be heard at the public hearing absent that notice? If we go to the language used by West Villages itself in the notice on record 1154, it states West Villages Improvement District notice of public hearings and regular board meetings. So they are noticing those separately. If we go to the notice that was published for the public hearings and the items that would be considered, they published page by page a breakdown of exactly what was going to be discussed. Nowhere in there does it mention, refer to, or provide any notice whatsoever regarding the proposed Resolution 2018-18, which was, again, was going to enable a 100-year agreement to be signed, obligating the residents of that district to pay $2.8 billion to the very people, the company of the very people who are voting for that. If we look, as your Honor and Judge Silverman noted, if we go to the record and look at the minutes of the meeting, it likewise could not be more clear that West Villages considered and treated that meeting as being separate, and that it was not the regular meeting. If we look on the record on 1283, it states very clearly the regular board meeting was then recessed and the public hearing was opened. And then it goes on to say, proof of publication was presented that showed the notice of the public hearing had been published in the Sarasota Herald Tribune on September 8, 2018, as legally required. So West Villages has said this isn't pure legalese. This is not boilerplate. This states that West Villages understood and took the position that it was legally required to provide notice of a public hearing that was separate from the regular board meeting. And it believed it did that. Only after it was discovered that they slipped it in 5 days instead of the required 7 days and gave a much lesser shrift than the regular board meeting agenda items, was it argued that they were never required in the first place to provide notice. At the end of
Mr. Aber, I think Mr. Brown, and just I want to make sure I have this correct from the record. The prior board meeting, you agree that there was discussion about the rates, is that right? And that they were going to continue that discussion for the next meeting? I think the minutes reflect that, right?
The minutes indicate that there was going to be a discussion, an ongoing discussion of rates, not that there was going to be teed up a irrigation rate study, an entire rate study that had been performed, and obviously the board knew of at that time, based on the dates in which the report was completed. But there was no notice to anyone in the public through those minutes that there was going to be a rate study presented and a resolution passed at the board meeting, in between the regular board meeting at the public hearing on the September 13th.
Thank you.
And if we look, the purpose of the enacting legislation, as well as the requirements of Sunshine Law, are to give reasonable notice and an opportunity to be heard to the people, not as a matter of inconvenience or something that the district can attempt to do unsuccessfully at a bare minimum level. This was a crucial and important issue that resulted in a multitude of increase in rates to these residents, directly to the benefit of the controlling board members who were members of the Mattamy Corporation or subsidiary thereof. The trial judge, who had an opportunity to sit and listen to the testimony about exactly what happened, what went down leading up to, including this September 13 meeting and thereafter, stated that the actions of the West Villages and its board of directors were patently unreasonable, unfair, and palpably obscene. This is not a situation where there are no harm, no foul, or we can't make the public come to these meetings. Gosh, we didn't know if they wanted to listen to this or not.
But those findings, yeah, but Mr. Herbert, those findings are with respect to the second issue, which is not before the court, correct? Those were under section 720 under the with Lennar, those issues. On the findings of the agreements.
The passage
being abstained.
I apologize, Sharon, I didn't interrupt.
Yeah, go ahead. No, I'm just saying that I think those findings were with respect to the second issue that is not before the court, that the trial court heard.
They were announced during that portion. I think fairly looking at the record would indicate that the Judge Carroll's comments flowed from the process and the activities that were undertaken in order to lead to where the process ended up, in not insubstantial part in regard to the utter failure to provide reasonable notice, attempts to provide as little notice as possible, and then an ongoing practice that led to the later passage of two different agreements based on that resolution to 2018-18. But the fact is, the message needs to be sent to the appellant, to West Villages, that it works for the people of its district and should be providing notice to the people. It does not work for Mattamy, and it should not be acting in the interests of the master developer. It should be acting in the interests of the community. That means providing accurate, adequate notice, reasonable notice under 189.015 and under the governing legislation. That means not simply sliding in a public hearing in between the recessed and then reconvened regular board meeting, of which no one had reasonable opportunity. We heard there were questions and suggestions that, well, we publish notice on the website. That's a non sequitur and a red herring. The district has already admitted that its website does not comply with the requirements of 50.0311, and it does not act as a public notice instrument. In fact, the suggestion that there was evidence and testimony that suggested it was possible that the website itself was deselected for searching on Google and other search engines. So it wasn't even available to the general public at large. And there was an email blast that only went to Mattamy insiders and those people who happened to reach out directly and request to be added to the email list. So if we're talking about an opportunity to be heard, that doesn't mean, as the district recognized, Mr. Crowley testified, people don't come to these meetings unless they're told that there's an item of business that's going to be discussed that's of particular interest to them. And the district knows this. And to fail to provide adequate notice of such a key and crucial resolution is to deny an opportunity to be heard to the people of the community. And that doesn't serve the interest of the community. It doesn't serve the interest of the actual improvement district itself. It only serves the interest of the people who stand to benefit from the passage of Resolution 2018-18 and its progeny. If your honors don't have any further questions, I believe we've covered the portions that I intended to cover in my, although a little out of order, but I think we covered everything that I wish to cover.
Thank you, counsel. Appreciate it. Mr. Brown, you have 4 minutes remaining.
Thank you, Your Honor. On the notice issue, counsel for Grand Paradiso pointed to the appendix, pages 1154 to 1157, which is the notice that was published by the district regarding its levy assessments and budget, and in addition included further notice of the regular meeting on September 13th, 2018. I think that's a great example. There is the legislature saying, here is a particular topic on which you shall have a public hearing, and the legislature is saying, you shall publish a notice of this public hearing, which is what the West Villages Improvement District did. That is not the case in the charter. Again, yes, a public hearing is required, a public hearing was held, but there are no notice requirements associated with that.
Mr. Brown, that's it. That language also exists in the publication for the irrigation. It's the notice of public hearing on irrigation rates by West Villages Improvement District. It says in the second paragraph, in accordance with Chapter 2004-456 Laws of Florida as amended, and Chapter 120 Florida statutes, the district hereby gives the public notice of its intent to adopt proposed rates, etc. It also goes on to say that in the third paragraph, the proposed rates may be adjusted at a public hearing pursuant to a discussion by the Board of Supervisors and public comment. Although I wonder how that could have happened when the Board of Directors recessed at the public hearing. So anyway, this is the language of the publication. Whether it was error on your client's part to publish it that way, it is here, and we have it to consider.
The two other points, Your Honor, on the notice question. Counsel mentioned the agreements between the parties. The order in this case enjoins West Villages Improvement District from applying those agreements. There's nothing in the record, any discussion about those agreements having been adopted outside of the Sunshine Law. And there's nothing to say that those agreements couldn't have been approved or adopted regardless of Resolution 2018-18. Each of the irrigation agreements that are discussed in the record that are included in the appendix have provisions that allow West Villages to adjust its rates and recognize and reserve its authority to adjust those rates. So just because Resolution 2018-18 is alleged to have been adopted outside of the Sunshine doesn't mean that any of these other agreements.
But those agreements are based on the new rates, are they not?
Your Honor, they reference the new rates, but they don't rely on the new rates. West Villages and Grand Paradiso could enter into an irrigation agreement. The question is, what are the rates under that agreement? And as I've noted, each of those agreements, for example, the original 2009 agreement that is part of the record, that's appendix page 1006. Section 7 of that agreement recognizes and reserves the ability of the district to adjust its rates. So the question would be, what are the rates if 2018-18 doesn't exist? Not, is that agreement void? Not, are the subsequent irrigation agreements void that included similar language? The same is true of the agreement that deals with the district's access to wells and groundwater for purposes of meeting its irrigation service with Thomas Ranch Intangibles and Ranchland Operations, who weren't even before the court, by the way, non-parties. That agreement references Resolution 2018-18, but there's no case law cited. There's nothing in the record that suggests how or why the district could not have entered into that agreement and subsequently adopted rates after a public hearing. So again, and there's nothing in the record that says any of those agreements were adopted or approved outside of the Sunshine. Just that somehow, ipso facto, without any authority I'm aware of that would suggest this, that because they reference 2018-18 somehow, that they too must be void if there was a Sunshine Law violation with respect to adoption of Resolution 2018-18. With respect to the website,
and aren't those the two agreements? Or maybe we're not talking about the same thing, but I want to make sure. Aren't those two agreements the same ones that the court said were palpably obscene?
The one agreement that deals with the district's access to wells and groundwater, Your Honor, was not referring to the separate agreements dealing with the provision of irrigation service to Grand Paradiso.
Okay, thank you.
With respect to the
Mr.
website.
Brown, your time has expired, so let me give you 30 seconds to sum up.
Thank you, Your Honor. In summary, because the Grand Paradiso is unlikely to succeed on its sunshine law claims, the order should be reversed. We hadn't discussed it during oral argument today, but it should also be reversed because the order below disturbs rather than preserves the status quo in this case. Finally, Your Honor, on separate grounds, the order should be reversed because it is overbroad and reaches the ultimate relief requested in Grand Paradiso's complaint rather than the relief actually requested in their motion for preliminary injunctive relief, and because it interferes with the rights of non-parties, namely the cross parties, Judge Smith, to your question, in the agreement dealing with access to wells and groundwater, who were not parties before the court. Thank you.
Thank you, counsel. Thank you both. Well presented, and that will conclude this case for today. I guess electronically you get to go back to the point of your electronic origin to come here, and you're more than welcome to listen to the remaining two cases should you wish to, or